Welcome to Q&A practice. We'll start with the plaintiff attorney. Ready? Here we go. Especially if the defense intends to pursue their planting of Mr. Avery's blood evidence, and the court, I'm sure, on its own can surmise the argument that the state may make if in fact planting evidence is going to continue to be advanced in this case. The negative evidence, that is, the lack of evidence in the flatbed, has similar evidentiary value, and whether the state intends to argue directly the implication of negative evidence or just the fact that the state looked, the fact that the state in fact did a thorough investigation all has at least some relevance in this case, and the showing of these two photos are not in and of themselves prejudicial. They will both be referred to later in this trial, and at this time I think it's proper for the court to not reject or exclude those photos as exhibits. Thank you. All right, I'm satisfied that at least at this stage of the trial, both of the photos offered have at least the potential for probative value for the reasons stated. Among other things, the thoroughness of the state's investigation can be put into play later in this case. I do have one question. However, does the state have photos of either the Pontiac Grand Am or the flatbed that doesn't have evidence tape involved? I can check, Judge. I don't know that we have the flatbed, the Grand Am. We may have photos at the crime lab, and that is something that I can certainly inquire into. But these were the first photos. I don't know that evidence tape in and of themselves, since the jury will hear they were processed, is anything prejudicial at all. But I will check for the court. All right, let's have the parties report back at 1 o'clock. Then the first order of business will be hearing from the defense. Yes, I would like a little more time than 1 o'clock. If I could get 90 minutes, I think that would be enough. All right, we will give you until 1:15. Okay, you may be seated. At this time, we're back on the record outside of the presence of the jury. I will indicate for the record that I met with counsel briefly in chambers before we began. It's my understanding, I believe, that we have an agreement on how we are going to proceed this afternoon, and that involves specifically taking a witness out of order. Is that right, counsel? The state understands, Your Honor, that the defense has asked for an opportunity to defer its cross-examination of Bobby Dassey until the beginning of court tomorrow. We understand that the defense wishes an opportunity to interview Mr. Dassey sometime yet this afternoon, and the state is prepared to call Trooper Austin and have him present his testimony before the cross-examination begins, which, as I understand, the defense has asked for leave to commence that tomorrow morning. Mr. Strang, I had suggested in chambers that our conclusion and the defense's statement was that we did need to interview Bobby Dassey before cross-examining him, and that we wished to cross-examine him only once so as not to draw undue attention to him or to any part of his testimony, because that is an interview that is of unpredictable length and will take us in different possible directions, some of which I can predict as possibilities, and I'm not sure I can predict all of the possibilities. I had asked that we have the balance of the day to do that, and that we start tomorrow morning with the cross-examination of Bobby Dassey, so that for the jury this just flows sequentially, and you know the fact that the court had to resolve some issues is all the jury would know. In chambers, as I understood the court, it was unwilling to adjourn for the afternoon and start up again tomorrow morning. I object to taking another witness out of order, because I expect that as I understand this trial, then Bobby Dassey will be the only witness whose cross-examination did not immediately follow in order with his direct examination. That is, it was broken up by another witness. The court, of course, controls the mode and the order of the interrogation of witnesses, but this does not tend to highlight him, and also it leaves us attending to Trooper Austin, which that time probably would be better used and should be used in interviewing Bobby Dassey and adjusting the cross-examination of Bobby Dassey. Accordingly, doing a 1.5 or 1 hour witness is better than having no time to interview Bobby Dassey at all, to be sure, but I don't think this is an adequate remedy, and as I forecasted in chambers and won't repeat here, there are a number of possible issues that we may need to visit or revisit depending on the results of the conversation with Bobby Dassey. But in any event, I do ask the court then to exempt us or to carve an exception for Mr. Budding and myself and our defense investigator this afternoon so that we can talk to Bobby Dassey here during the midst of his testimony, so to speak. But we would ask that the court's earlier order remain in place for agents of the state other than Mr. Leverns, who of course, as a practical matter, has to have some communication with Bobby Dassey about the court's schedule and plans. Mr. Kratz, thank you, Judge. As the court knows, in chambers, it was the state's request that the defense proceed directly with cross-examination. I will have an exhibit marked for the court, which I alerted the court and reminded counsel that they already had in their possession pages 516 and 517 of the Sheriff's Department discovery, which is now a second place within the material that Mr. Strang already had, which the defense counsel to the substance of and the surrounding circumstances of the interview that Mr. Dassey mentioned in his direct testimony, to suggest to this court at this time that it was not until this very moment that the defense realized the significance of Bobby Dassey, when they have known for well over a year that Bobby Dassey was the last person other than their client to see Ms. Hallback alive and walking toward Mr. Avery's trailer, to suggest it's only now that they believe it important to interview Mr. Dassey. The state believes to be disingenuous. That notwithstanding, Your Honor, we understand why the defense has made this request. We do disagree that after Mr. Strang and Mr. Budding have an opportunity to interview Mr. Dassey, that the state should somehow be prohibited or precluded from ourselves interviewing or speaking with Mr. Dassey. That is a separate issue, of course. And with that exhibit now having been provided to the court, we don't believe that we have any further need to make any further record on this issue. Thank you, Judge. I acknowledge that I have had in my possession pages 516 and 517 of the Calumet County Sheriff's Department report. It's not well over a year, of course, because Mr. Budding and I have first entered our appearances less than a year ago in this case, but we have had that report and those 2 pages for months. And in any event, I wish that the question of the interviewing of Bobby Dassey were as easy as whether he is important or not. That is not the question. There are a whole lot of other dynamics at work here, such as the availability of witnesses and the allocation of resources and some of those things. We don't need to rehash all of the arguments about why the defense had wanted a trial date later than February 5, 2007, but it's not all that easy. I can say and should say that we have not interviewed Bobby Dassey at any time, and we hope to be able to do that today. And the issue in the end, I think, under section 971.231b comes down to the meaning of witness and whether here we are provided notice by the state that Bobby Dassey will be a witness to testify to the oral statement at issue, materially different as it is from Mr. Osmundson's rendition, and some differences from the second-hand rendition from another witness in pages 516 and 517, and just recounting to a law enforcement agent that Bobby Dassey supposedly said to him about what Stephen Avery said in Bobby Dassey's presence. So I think we have got a record I have made and I will renew the mistrial motion and the request for lesser relief, with the least favorite alternative being given the afternoon here to attend just to Bobby Dassey, and resuming the trial with the jury tomorrow with Bobby Dassey's cross-examination. I understand the court has ruled on that. I just wanted to make our position clear. All right, first of all, the court has already denied the motion for a mistrial, and I have heard nothing to make me change that. Since the matter was brought up on the record this morning, the state has presented the court with another piece of discovery which makes reference a little more directly to the statement that was the subject of the defense motion here. Given the fact, nevertheless, that the witness himself in his own statements apparently did not make reference to the information contained in the other two documents that highlighted the witness's exposure to this alleged statement on the part of the defendant, I agree that the defendant should be permitted from some time to explore this issue and to interview the witness. I have not been presented a reason why such an interview should require hours of preparation, since the defense has had the opportunity to interview this witness for as long as this case has been pending. There is only one narrow issue, specifically the witness's testimony as to one statement on the part of the defendant, that gives rise to the need for another interview. I'm confident if we break a little earlier today and the defense has an opportunity to interview the witness, that should be sufficient to address any problem that may exist. All right, we will stop there. That will conclude our Q&A practice for now.